This October 2022, after my previous reel on associate member in a cooperative society and their rights, in Maharashtra, under Maharashtra Cooperative Societies Act, there are several queries. Now, whatever I am saying is as per provisions of Amendment 2014, because subsequent amendment, constitutional amendment, is struck down by the Supreme Court. So now Section 24 of 2014 Amendment Act says for 24(2), subsection 2, a nominal or sympathizer member shall ordinarily not have any privileges and right of a member, but such a member or an associate member may, subject to the provisions of subsection 8 of section 27, have such privileges and rights and be subject to such liability of a member as may be specified in the bylaws of the society, provided the society has adopted the bylaws. If you have not adopted, it is not applicable. So bylaws supersedes the statute. Section 27(8) now says that no nominal or sympathizer member shall have the right to vote, and no such member shall be eligible to be a member of the committee or for appointment as a representative of the society or any other society. Going further, now let us concentrate on the rules. What does 1961 Cooperative Society, Maharashtra Cooperative Society rule says? Rule 56M says about the nomination of candidates in the election. It says that any person may be nominated as a candidate for election provided he has paid all the maintenance charges, that is condition precedent, for election to fill a seat. If he is qualified to be chosen to fill that seat under the provisions of the Act and these rules and the bylaws, and if his name is entered in the voters list, provided in case of joint or associate member, only the member whose name stands first in the share certificate shall be eligible to be nominated as candidate for the election. Where the seats are reserved, now there is an exception to this general rule, which says that when the seat is reserved for scheduled caste and scheduled tribes, under section 73B of the Act, any individual belonging to the categories provided under subsection 3 of section 73B shall be eligible for being nominated as candidate even if his name does not appear in the list of voters. As far as voting right of an associate member is concerned, there is a provision in the bylaw. It says that no associate member shall have any right or privileges of an active member except as provided under section 27(2) of the Act. Now what section 27(2) of the Act says? Where a share of a society is held jointly by more than one person, the person whose name stands first in the share certificate, if present, shall have right to vote, but in his absence, the person whose name stands second, and in absence of both, the person whose name stands next, and likewise, in absence of the preceding persons, the person whose name is next on the share certificate, who is present and who is not minor, shall have the right to vote. So if the other when associate member's name is third and previous two members are not there, then he can cast his vote. Now bylaws further says that another qualification is he fulfills the conditions of bylaw number 22A. That means he has paid maintenance in full and there is no other outstanding. This is the law which I am saying and about the associate member.